Hi, you guys. So, I shared this Georgia Court of Appeals decision. I made a community post. And I was like, oh, okay, cool. They're reversing Judge McAfee's decision, at least on the part to disqualify Fani Willis and her office. So, according to this Court of Appeals decision that just came down today, Fani Willis can't try this Trump RICO case. Fulton County, her whole office cannot try this Trump RICO case. That isn't the most immediate news with immunity. We probably weren't going to see this case move forward for 4 years. But in reading this decision, I'm a little confused because it seems a bit empty. And again, this is only the Court of Appeals. It's not the Georgia Supreme Court. So I feel like this might not be the end of the line. I feel like we might see a little bit of escalation here to the Georgia Supreme Court. There is a dissenting opinion, and let's go through it and see what you guys think. Also, holy moly, big shout out. Classy Beats is here up and early, 20 gifted membership, so I better see some love for Classy Beats in the chat. This is super, super awesome. I am surprised that Classy's not live right now. I'm going to make the assumption that, oh, well, it's 10:30, so maybe you did your show already. Let me double check and see if he's going to be going live soon. Okay, going live soon. So what we'll do, guys, we will end up redirecting over to Classy Beats when we get through this reading. And it looks great. You're going to go on, Classy's going to do the update on Yak Gotti's bond being denied and more on Christian Eppinger. So this is going to be really good. Drop a link to that here. And this is going to be a quick one, guys. We're going to go through this filing. We're going to look at it. We're going to ask some questions, and then we're going to get over to Classy. So there's a link for now, and we will redirect. But what is going on with this filing? And it's like bare bones. This was provided by, let me get his Twitter link, Anthony Michael Crease. And his link is here if you want to follow him over on X. This is who I'm talking about. There you go. Always appreciate whenever somebody provides the link for what they're talking about, because I like to read the stuff. Especially today, it's especially interesting. So I'm going to move my picture so we can see it better. And we've got dated today. And remember, with the Trump RICO case, we have all these co-defendants, tons of co-defendants. We call it the Trump RICO case because that's just, that's the razzle dazzle, right? Everybody knows Trump's name. But really, one of the major reasons that we got to where we are today is when Ashley Merchant, who represents Michael Roman in this matter, filed the motion to disqualify Fani Willis and her office from prosecuting this case. And a lot of that is centered around a conflict of interest and the debate whether it was an appearance of or actual, and whether either was enough to disqualify Fani Willis and or her office. Well, Judge McAfee, the trial judge, made the decision that, well, there is an appearance of conflict. There is an odor of mendacity. Kind of seemed like Judge McAfee was like, I don't really know why you would have decided to do this, you guys, but you did. But it's only an appearance. And I think a sufficient remedy would be either Nathan Wade has to go or Fani Willis has to go from prosecuting as an individual this Trump RICO. So after that decision came down, we got this resignation from Nathan Wade. Fani Willis wrote a response letter thanking him for his time and showing him some appreciation. And then it's just kind of been in limbo ever since. Well, with this appeal up to the Court of Appeals in this decision, now the whole office is out. Whole office is out. But the Court of Appeals didn't really make any solid decision otherwise. They just said, we don't think the remedy that you took was enough. So I thought it was an interesting read. I've got some questions. So this is Judge Brown writing this. Michael Roman, David Schaefer, Robert Cheeley, Mark Meadows, Donald Trump, Kathleen Latham, Rudolph Giuliani. Weird to see his name spelled out. Jeffrey Clark and Harrison Floyd, collectively the appellants, were charged in a 97-page indictment with RICO violations and other crimes in connection with an alleged conspiracy to unlawfully change the outcome of the 2020 presidential election. Pursuant to a granted interlocutory application, The appellants appeal from the trial court's order denying their motion to dismiss the indictment and granting, in part, their motions to disqualify the Atlanta Judicial Circuit District Attorney Fani Willis and her office. So this granting, in part, was one of them has to go, and that ended up, the choice was that it was going to be Nathan Wade. That was how it was granted in part. Collectively, the appellants assert numerous grounds to reverse the trial court's order, including that the trial court imposed an improper remedy after concluding that D.A. Willis's prosecution is encumbered by a significant appearance of impropriety, not grounded on mere status alone, but instead resulting from specific conduct impacting more than a mere nebulous public interest because it concerns a public prosecutor. In response, the state asked this court to affirm the trial court's order in its totality, including the imposition of an alternative remedy requiring that either D.A. Willis, along with the whole of her office, step aside and refer this case to the prosecuting attorney's counsel for reassignment, or Special Assistant District Attorney Nathan Wade, who they're going to call SADA Wade, withdraw from the case. So the state's basically saying, like, don't change. Like, look, we did this remedy. Please affirm Judge McAfee's decision. Importantly, the state has not filed a cross appeal asserting that the trial court's finding of this appearance of impropriety should be reversed. Now, this is pretty important because what we're going to continue to read, this Court of Appeals decision is going to be based on Judge McAfee's finding that there was an appearance of impropriety, and the state's not challenging that in their response. Accordingly, whether the evidence presented to the trial court adequately supported under the appropriate standard of review on appeal, it's finding that the existence of an appearance of impropriety is not before this court. Instead, so what are we looking at? We must determine whether the remedy fashioned by the trial court for this undisputed finding of a significant, in quotes, appearance of impropriety was improper as contended by the appellants. So we're not looking at, whether there was an appearance of impropriety. We're not looking at that. We're not even looking at whether or not it is significant or not. But we're going to look at the remedy. That's what's at question. And part of that is because, I don't know, they're indicating to me that if the state pushed on it, they might have actually considered that type of argument if the state took it there, but they didn't. So for the reasons explained below, we conclude that it was, and therefore reverse the trial court's denial of the appellant's motion to disqualify. So you didn't fight it, and we're going to reverse Judge McAfee by saying, this little partial getting rid of one person and you guys chose Nathan Wade, that's not enough. That's not enough. We affirm, however, the denial of the appellant's motion to dismiss the indictment. So that was a sanction, a very extreme, extraordinary sanction that was requested. As a sanction for this, get rid of the indictment entirely. Judge McAfee said no, and the Court of Appeals says no, we're not doing that either. Now, a motion to disqualify in special grand jury proceeding. On January 24th, 2022, the Chief Judge of the Superior Court of Fulton County impaneled a special grand jury at the request of D.A. Willis for the purpose of investigating the facts and circumstances relating to possible attempts to disrupt the lawful administration of the 2020 elections in the state of Georgia, including the decision by the state Republican Party officials to draft an alternate slate of presidential electors. D.A. Willis served as the legal advisor to the special grand jury, which began receiving evidence in June of 2022. Around the same time, D.A. Willis hosted and headlined a fundraiser for an opposition candidate against Burt Jones in a lieutenant governor race. After she later publicly identified Jones as a target of the grand jury's investigation, he and 11 other alternate electors sought to disqualify D.A. Willis and her office, based upon an actual conflict of interest. The Superior Court overseeing the special grand jury proceeding disqualified D.A. Willis and her office from any further criminal investigation or prosecution of Jones based upon a plain and actual and untenable conflict. And this was the reasoning for that decision. It reasoned that concern about the district attorney's partiality naturally, immediately, and reasonably arises in the minds of the public, the pundits, and most critically, the subjects of the investigation that necessitates the disqualification. So, whatever it is that's going on, the concern makes a difference. We saw a little bit of this in oh, what is it? Rachel Krause? Judge Rachel, is it Judge Rachel Krause? First name Rachel? You know, she seemed to hint that in her decision to disqualify Judge Earl Glanville in the YSL trial, you know, make him actually remove him from the case, she seemed to make a big consideration of public concern, public interest, right? So this stuff's important. An investigation of this significance, garnering the public attention it necessarily does, and touching so many political nerves in our society, cannot be burdened by legitimate doubts about the district attorney's motives. The district attorney does not have to be apolitical, but her investigations do. The Superior Court denied the motion to disqualify filed by the remaining alternate electors because they failed to show an actual conflict of interest with DA Willis or any member of her prosecution team. Its order did not explicitly address the appearance of impropriety as a ground to disqualify. After the special grand jury issued its final report recommending criminal charges against the appellants and others, it was dissolved on January 9th, 2023. And if you ask me, it seems like the Court of Appeals is telling us this because they're about to not explicitly address certain things, right? They're going to say, look, we're just going to accept that Judge McAfee said there was an odor of mendacity, just like happened in this decision here, right? So in a way, they're saying, here's where we're getting our authority to write this decision in this way. And then the motion to disqualify following indictment. On August 14th, 2023, DA Willis secured the RICO indictment against the appellants and 10 others. On January 8th, 2024, Roman filed a motion to dismiss the indictment and disqualify DA Willis, her office, and SADA Wade from further prosecuting this case on alleged grounds of conflict and an appearance of impropriety. Now, remember back in the day, you know, and this was this year, but it feels like so long ago. Well, that January motion to disqualify, when that came down, at first there was a denial. There was a denial of this type of relationship. And then as things progress, well, it's a relationship, but it's not, there's nothing wrong with it. And then we get this decision from Judge McAfee that's kind of like, it looks enough like there could be something improper here. The appearance is there, right? That's where we got to. After DA Willis spoke publicly in a church service on Sunday, January 14th, 2024, the other appellants also filed motions seeking dismissal and disqualification on the same grounds, as well as the additional ground of forensic misconduct in connection with the church speech and various other extrajudicial statements. The trial court's order. So on March 15th, 2024, the trial court entered its order on the motions after conducting a multi-day evidentiary hearing. That feels like so long ago. It summarized the issues and its followings as follows. As alleged, the claims presented a possible financial conflict of interest for the district attorney. More importantly, the defense motion and the state's response created a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedural due process. After receiving 2.5 days of testimony, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, the court finds that the defendants failed to meet their burden of proving the DA acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are also denied. Now, guys, if you're just tuning in, what we're reading, this Court of Appeals decision today is citing the trial court's decision, Judge McAfee's decision. That's what we're reading. That's kind of like indented extra on this margin here. This whole block is from that decision earlier this year. The other alleged grounds for disqualification, including forensic misconduct, are also denied. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one of two options, and this was the choice. The district attorney, Fani Willis, may choose to step aside, along with the whole of her office, and refer the prosecution to the prosecuting attorney's counsel for reassignment. Send it somewhere else. Alternatively, SADA Wade, Nathan Wade, just himself, can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration, distracting from and potentially compromising the merits of the case. The trial court made the following findings of fact in its order. So they're going to go through the findings of fact. And I missed a footnote. Okay, so there's a footnote here after they say during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster. There's a footnote that says the transcript reveals that the trial court precluded cross-examination of DA Willis about matters related to forensic misconduct, as well as county codes and ordinances. It appears that the trial court limited the evidence in the hearing to the relationship and or any financial elements of it, in an off-the-record ruling referenced in the transcript. The record before us contains no authenticated recording or transcript of the church speech, and it was never introduced into evidence at the hearing. The appellants do not assert on appeal that the trial court erred by limiting their cross-examination and introduction of evidence in the hearing. So we're getting this on paper here that, hey, we know another basis for disqualification was argued, but it really wasn't the subject of this appeal that the defendants brought forward. And really, we're just going to notate that it wasn't really a significant part or an accessible part of these hearings, these proceedings. So they're not going to really address the forensic misconduct in this decision. On November 1st, 2021, the district attorney hired Nathan Wade to serve as SADA and lead the investigation that produced the indictment in this case. And this is, remember, at the beginning of this decision, this Court of Appeals, they're saying, look, we're not expecting the DA. We're citing another decision where it was stated that the DA isn't expected to be apolitical, but they're investigators and investigations are, right? So here we're starting with the problem. The district attorney hired Nathan Wade to serve as SADA and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade, extending an offer to former Governor Roy Barnes, who declined. The contract allowed a $250 hourly rate, a relatively low amount by Metro Atlanta standards for an attorney with Wade's years of service, and contained a ceiling on the maximum number of hours permitted. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicates that Wade ever received permission to exceed those hourly monthly caps. His contract was renewed on November 15th, 2022, and again on June 12th, 2023. Between October 2022 and May 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. So we're going to go through all the trips, you guys. The first included an extended trip in October 2022 to Miami and Aruba on a cruise. Wade initially covered expenses for the October 2022 trip, totaling approximately $5,223. In December 2022, the two flew to Miami for another cruise, for which the DA paid $1,394 for plane tickets, while Wade purchased passage for the cruise along with other vacation-related expenses, totaling approximately $3,684. In March 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of approximately $3,000. In May 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides in the amount of around $2,829. In addition, the two described taking a number of day-long trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. Guys, this question, I think it was about Tennessee, was my favorite question of all of those hearings. Ashley Merchant was up there in disbelief, asking this man, Nathan Wade, if he's ever been in a cabin, if he ever stayed in a cabin with Miss Merchant. And Nathan Wade goes, I don't remember. Like, it was the longest pause I've ever seen someone give an answer to. That was a whole moment in those hearings. And Ashley Merchant's just standing there like, is this for real? Like, it seemed like the stream froze. He just paused for so long. Maybe if we can get to that clip quickly. Actually, I think I clipped it in a different video. So if you guys don't mind rewatching a video with me in it, we can replay that clip. In any case, They also admitted to dining out on multiple occasions and taking turns covering the bill. With seemingly full access to Wade's primary credit card statements, the defendants did not produce evidence of any further documentable expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of at most approximately $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Both testified that the district attorney regularly reimbursed Wade in cash, and if not reimbursed, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him money for both cruises. She further claimed that she reimbursed Wade for the entirety of the Belize trip, and that she paid for the Napa Valley excursions. Finally, while Wade could have bought out meals in 2020, which totaled more than $100, she would also regularly pay for his meals. Such a reimbursement practice may be unusual, and the lack of any documentary corroboration understandably concerning. Yet, the testimony withstood direct contradiction, was corroborated by other evidence, for example, her payment for airfare for the two on the 2022 Miami trip, and was not so incredible as to be inherently unbelievable. However, as the district attorney herself acknowledged, no ledger exists. Other than just a best guesstimate, there is no way to be certain that expenses were split completely evenly, and the district attorney may well have received a net benefit of several $100s. Despite this, after considering all the surrounding circumstances, the court finds that the evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was, or currently remains, greatly and pecuniarily interested in this prosecution. In addition, and much more important, and again, I think these are always like, when we get this emphasis, you got to pay attention to it. The court finds, based largely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute this case. So, again, we're looking at the original Judge McAfee's decision here. And this is why it's hard to tell if you just came in here, but this is why the margins are so indented. Everything that we've been reading for like the last page and a half is just a recitation of Judge McAfee's decision, right? And when this is emphasized, the Court of Appeals has to acknowledge that this is emphasized, that this was an integral part of Judge McAfee, the trial court's decision. So, Judge McAfee did not find that the financial gain from the relationship was a motivating factor on the part of the DA to indict and prosecute the Trump RICO case. While the general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in any great need, as she testified that her salary exceeds $200,000 per year without any indication of excessive expenses or debts. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. While prejudice is not a required element for disqualification, it is relevant to considerations of due process and the defendant's requested remedy of complete dismissal. Defendants argue that the financial arrangement created an incentive to prolong the case, but in fact, there is no indication the district attorney is interested in delaying anything. Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested that trial begin less than 6 months after indictment. Soon thereafter, the state opposed severance of the objecting defendants who did not demand their statutory right to a speedy trial. The state argued that it only wanted to try the case once, assuming that such a trial would be affirmed after any necessary post-conviction appeals. The state amended its proposed timeline in November 2023 to request that the trial commence less than 1 year after the return of the indictment. And even before indictment, the district attorney approved a grand jury presentment that included fewer defendants than the special purpose grand jury recommended. In sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of this prosecution or engaging in excessive litigation. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution, or that her financial arrangements had any impact on the case, the defendant's claim of an actual conflict of interest must be denied. This finding is by no means an indication that the court condones this tremendous lapse of judgment. And this was like, this is the line where everyone was like, all right, Judge McAfee definitely splitting the baby here. This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly. And it's the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. So, most of this decision so far from the Georgia Court of Appeals is giving us the entire Judge McAfee decision, the trial court decision. Although the court found insufficient evidence of an actual conflict of interest, it also concluded that, so we're back to quoting McAfee, the record made at the evidentiary hearing established that the district attorney's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after SADA Wade's initial contract in November 2021, the district attorney chose to continue supervising and paying Wade while maintaining such a relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of a confirmed financial split creates the possibility and appearance that the district attorney benefited, albeit non-materially, from a contract whose award lay solely within her purview and policing. Most importantly, were the case allowed to proceed unchanged, the prima facie concerns raised by the defendant would persist. As the district attorney testified, her relationship with Wade was only cemented after these motions and is stronger than ever. And remember, this all came before the news that, they're still friends. Nathan Wade was showing up, helping out when the daughter got pulled over. And so McAfee made note of that before all that was still known. But at that point in time, Wade's patently unpersuasive explanation. Imagine somebody calling your argument patently unpersuasive. So Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. There's a footnote here. DA Willis and SADA Wade testified that their personal relationship ended sometime in the summer of 2023. Interesting footnote. Interesting footnote. Put differently, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. As long as Wade remains on the case, this unnecessary perception will persist. The testimony introduced, including that of District Attorney and Wade, did not put these concerns to rest. During argument, and again, we're still going through all of McAfee's, the trial court's decision here. Like, this Court of Appeals is just like, run the whole thing back. During argument, the defendant's focus largely pivoted from the financial concerns to disproving the testimony of the district attorney, namely that her romantic relationship actually predated the November 2021 hiring of Wade. On that front, the court makes a few brief observations. First, the court finds itself, we're getting the name, guys, finally, he's being mentioned. The court finds itself unable to place any stock in the testimony of Terrence Bradley. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation upon which to build any conclusions. While prior inconsistent statements can be considered as substantive evidence under Georgia law, Bradley's impeachment by text message did not establish the basis for which he claimed such sweeping knowledge of Wade's personal affairs. In addition, when the testimony of Robert Nearty raised doubts about the state's assertions, it ultimately lacked context and detail. Even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of the other evidence, neither side was able to conclusively establish by a preponderance of the evidence whether the relationship evolved into a romantic one. However, an odor of mendacity remains. I got a footnote here. Mendacity means untruthfulness or tendency to lie. I feel like this footnote, I feel like they put this footnote here expecting the public to read it. I don't think they're putting this footnote here for the relevant parties to have defined what mendacity means. This seems like this footnote here was for the public. Personally, I think so. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Yet, reasonable questions about whether the district attorney and or hand-selected SADA testified untruthfully about the timing of their relationship further underpin the finding of an appearance of impropriety and the need to make proportional efforts to cure it. So now we have one line here where we're back to the Court of Appeals. All of that was Judge McAfee, the trial court decision on this matter. So Court of Appeals jumps in to say, the trial court, then rejected dismissal of the indictment and disqualification of DA Willis and her office based upon the following reason. Now we're back to McAfee's decision. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud of impropriety and potential untruthfulness found here. There has not been a showing that the defendant's due process rights have been violated, or that the issues involved prejudice the defendants in any way, nor is disqualification of a constitutional officer necessary when a less drastic and sufficiently remedial option is available. In other words, the district attorney's selection of whether Wade would withdraw or she would refer the case to a prosecuting attorney's counsel for reassignment. So the choice. The appellants contend that the trial court's failure to disqualify, and I think this is back to, now we're finally back and hopefully for good, to the Court of Appeals. This is going to be the Court of Appeals now. The appellants contend that the trial court's failure to disqualify DA Willis and her office was erroneous in light of the trial court's finding that the record established that the prosecution is encumbered by a significant appearance of impropriety. In the appellant's view, the trial court's forward-looking remedy did not cure the already existing appearance of impropriety and the, quote, odor of mendacity found by the trial court. Based upon the fact findings of the trial court in its order and the state's failure to cross-appeal the trial court's finding of a significant appearance of impropriety, we agree. So again, the argument here that the Court of Appeals is giving, based on the facts finding of the trial court. So that entire recitation of Judge McAfee's decision for like 5 pages there, based upon the fact findings of Judge McAfee and the state's failure to cross-appeal the trial court's finding. Again, we saw that at the very beginning of this decision. The Court of Appeals is like, state, bro, you didn't give us anything to contest the appearance of impropriety, especially since it was called significant. Not meager, not a little bit, yeah, maybe insignificant, significant appearance of impropriety. Because you didn't challenge it, and because of what Judge McAfee said, we've got to agree that there was a significant appearance of impropriety. We're not going to contest that finding, and you didn't challenge it. This is important. And in my opinion, this is kind of like the crux of this decision, of this ruling. The state didn't fight it. Judge McAfee hinted enough at it. He said it enough. We don't really get that much case law as we go through this, though. So, as our consideration of the appearance of impropriety is limited to the remedy fashioned by the trial court, because the state didn't press on this, we turn to Georgia law on this issue. While the parties advocate for diametrically opposed bright-line rules, one side wants disqualification of the district attorney's office, which can never result from the appearance of impropriety, or disqualification should always result. Always result, right? Those are the two arguments. You must always disqualify when there's an appearance. No, there's no law that says you ever need to do that, right? Polar opposite, diametrically opposed arguments. Georgia law requires neither as a matter of course. Instead, we must examine the particular facts and circumstances of each case while keeping some general principles in mind. First, the trial court's ruling on a motion to disqualify is reviewed for an abuse of discretion. They say, see Newman v. State, it's a 2021 case. Second, the issue of attorney disqualification is viewed as a continuum. Now, this is important because we're getting this whole paragraph saying there is no delineation here. There's a spectrum. It's a continuum. And, some discretion has to be used because it's not delineated. It's not clearly delineated. There has to be some discretion. And really what we would typically review is if that discretion was abused, if it went too far beyond a reasonable use of discretion, right? Now, typically what you'd see in an appeal decision like this is maybe some granularity, some delineation being carved out. We didn't really get that here, and that's why I decided to do this live. Now they're going to read from Blumenfeld versus Borenstein. At one end of the scale where disqualification is always justified and indeed mandated, even when balanced against a client's right to an attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidences. So that's one end, the far end of the continuum. In these instances, it is clear that the disqualification is necessary for the protection of the client. Somewhere in the middle of the continuum is the appearance of impropriety based on conduct on the part of the attorney. As discussed above, this generally has been found insufficient to outweigh the client's interest in his counsel of choice. This is probably so because absent danger to the client, the nebulous interest of the public at large in the propriety of the bar is not weighty enough to justify disqualification. Finally, at the opposite end of the continuum is the appearance of impropriety based not on conduct but on status alone. This is insufficient ground for disqualification. So, there you go. They spell out their continuum here. They also say, see Battle v. State, stating that the appearance of impropriety may be grounds for disqualification of a prosecutor. Not must. Not must. Here, we must address the remedy in the context of a significant appearance of impropriety caused by the conduct of a public prosecutor. So they lay out this paragraph here from Blumenfeld versus Borenstein that says, look, when you have this continuum, the low end, the no grounds for disqualification end, status isn't enough. In the middle, maybe the conflict isn't a big deal, and if there's no major public concern, public interest, without that public interest, it wouldn't be enough to warrant disqualification, which suggests what in the opposite? If there is a significant public interest, then disqualification, it would be a good use of discretion to consider disqualification, right? So they lay out this spectrum here. The Court of Appeals is looking at Blumenfeld versus Borenstein. And what do they say? So we must address this remedy of the trial court that Judge McAfee gave in the context of a significant appearance of impropriety caused by the conduct of a public prosecutor. In our criminal justice system, the district attorney represents the people of the state in prosecuting individuals who have been charged with violating our state's criminal laws. The responsibility of a public prosecutor differs from that of the usual advocate. Her duty is to seek justice, not merely convict. This special duty exists because the prosecutor represents the sovereign and should exercise restraint in the discretionary exercise of governmental powers. Therefore, the district attorney is more than an advocate for one party and has additional professional responsibilities as a public prosecutor to make decisions in the public's interest. In the district attorney's role as an administrator of justice, he or she has broad discretion in making decisions prior to trial about who to prosecute, what charges to bring, and which sentence to seek. That's from State v. Wooten. These considerations take this case out of the continuum of cases. So we have this continuum outlined, right? We get one end, this end, and then somewhere in the middle. But here the Court of Appeals is saying these other considerations take this case out of the continuum. We're not even in there when it comes to involving an appearance of impropriety in connection with the conduct of private counsel and a client's interest in counsel of choice balanced against a more nebulous public interest. That's all we get. That's all we get from the Court of Appeals here. This is the end of their citation. This doesn't really fall within this spectrum, right? We get some stuff spelled out. We say, this doesn't really apply to this. But then we don't hash it out. This is where I would expect the court to hash something out between this paragraph and this one. Because the next paragraph goes right into, we're going to find that the trial court made a boo-boo. But they don't spell out why and how to prevent it in the future. They don't really give something for future judges to look at and say, okay, I have a similar situation. Let's see what the Court of Appeals said recently on this matter. They don't do any further delineation. They just say, this isn't delineated. After carefully considering the trial court's findings in its order, we conclude that it erred by failing to disqualify DA Willis and her office. The remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed at times when DA Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. While we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated, and no other remedy will suffice to restore public confidence in the integrity of these proceedings. So this is the most important paragraph as far as this decision. Right? And I get that the chat is like, all right, yeah. But this is the Court of Appeals, and I feel like the state is likely to try to take this up and say, hey, hold on, Supreme Court of Georgia, hold on here, help us out. And even though they didn't seem to, according to the Court of Appeals, put up the fight that maybe they should have put up in this matter here, I don't know, this just seems like a little bit of, well, it's not delineated and we disagree with the trial court's finding in order, but we're not exactly spelling out why. So, like, I just wish it was spelled out more, right? What's the exact specific delineation here? And maybe this is on purpose, right? Maybe they don't want to delineate this. Maybe they somehow want to reverse this decision, but don't want it set in stone for future disqualification matters. They give a footnote here that our opinions in Head v. State, Billings v. State, Whitworth v. State, which is, gosh, that one was cited so many times in oral and written arguments, are distinguishable. In Head, we address an appearance of impropriety based upon status alone, where the investigator with the alleged status conflict took no part in the investigation or prosecution of the case. So that doesn't apply here because Nathan Wade, he was a party to the appearance of impropriety and was also like the special prosecutor. So doesn't apply. Similarly, in Billings, the assistant district attorney with the appearance of impropriety did not participate directly or indirectly in the prosecution of the case after joining the office of the district attorney. So again, no participation. Here, on the other hand, DA Willis and SADA Wade have been actively involved in this case from its inception. Division 1 of our opinion in Whitworth is non-binding physical precedent, and the case addressed only the disqualification of a special assistant district attorney. Likewise, the Supreme Court of Georgia's opinion in Frazier v. State, relied upon by the trial court, is factually distinguishable and does not require a different result. The issue before the Supreme Court was the disqualification of the entire district attorney's office based upon an assistant district attorney's conflict of interest rather than the conduct of the elected district attorney. So, and again, this is a little interesting because they did note earlier, hey, at the trial court level, you know, we didn't really get into the forensic misconduct issue all that much. So I wonder if they were like, maybe the Court of Appeals was salivating a little bit to get into that issue, but it wasn't the issue raised. Now, where was that footnote? That was on this page. Okay, so we finished this page. Very long footnote. Accordingly, we're back to the ruling here, out of the footnote. Accordingly, we reverse the trial court's denial of the appellant's motion to disqualify DA Willis and her office. As we conclude that the elected district attorney is wholly disqualified from this case, the assistant district attorneys, whose only power to prosecute a case is derived from the constitutional authority of the district attorney who appointed them, have no authority to proceed. That's McLaughlin v. Payne. And this is distinguishing between absolute disqualification of elected district attorney and disqualification of elected district attorney from serving as an advocate at trial because he was appearing as a witness. So this is why we have to disqualify Fani and her whole team. This choice was not the right remedy. To give this off-ramp for Nathan Wade to step away and say that that cured all the problems moving forward, that wasn't enough, right? We needed the whole disqualification of Fani Willis and her office. The appellants contend that the trial court erred in denying their motion to dismiss the indictment, right? They wanted this extreme sanction here. Get rid of this indictment because of all of this fuss with this impropriety, this appearance of impropriety. The state responds that the appellants have failed to show that the trial court erred in finding that the appellants had not shown that their due process rights have been violated or that the issues involved prejudiced them in any way. Dismissal of an indictment is an extreme sanction. It really is. It's used only sparingly for unlawful government conduct. Interesting. In the absence of express statutory authorization, dismissal of an indictment generally cannot be imposed absent a violation of constitutional right. While this is the rare case in which DA Fani Willis and her office must be disqualified due to a significant appearance of impropriety, we cannot conclude that the record also supports the imposition of the extreme sanction of dismissal of the indictment under the appropriate standard. So this is why at the beginning they said we're reversing on one finding, but we're affirming in part, right? We're not going to reverse Judge McAfee when he says that, nope, this isn't enough to just dismiss this whole indictment. They cite Olson v. State and Lamb v. State. We therefore affirm the trial court's denial of appellant's motion to dismiss. The appellant's remaining enumerations of error are rendered moot by our holdings in Divisions 1 and 2. And then the dissenting, Judge Land, gives a dissenting opinion. And I think this is interesting. I think this dissenting opinion is really interesting. So here we go with the dissenting opinion. Because the law does not support the result reached by the majority, I respectfully dissent. I am particularly troubled by the fact that the majority has taken what has long been a discretionary decision for the trial court to make and converted it into something else entirely. If this court was the trier of fact and had the discretion to choose a remedy based on our own observations, assessment of the credibility of witnesses, and weighing of the evidence, then perhaps we would be justified in reaching the result declared by the majority. But we are not trial judges, and we lack that authority. Given the unique role of the trial court and the fact that it is the court which has broad discretion to impose a remedy that fits the situation as it finds it to be, we should resist the temptation to interfere with that discretion, including its chosen remedy, just because we happen to see things differently. And why I think this dissenting opinion is so interesting is because we do have a footnote earlier in this ruling that's like, the majority is acknowledging, I think it was Judge Brown that wrote the majority decision. He acknowledges like, hey, there's some things that were off, like behind closed doors, off the record. We don't really know exactly what happened with these issues. And this is the point. That's the crux of this dissenting opinion. We don't know everything that the trial court judge knows, right? That's why you're supposed to leave it up to the trial judge to make the findings of fact. And as the appellate authority, we can look at issues with how those findings of facts may have played out as a matter of law, right? Or maybe in some cases, and this isn't really all that common, but just the sufficiency of the evidence, right? Is there enough even there to establish the facts that the court or the jury found, right? That's kind of a separate issue, but it exists. But I really do think this dissent is interesting. Doing otherwise violates well-established precedent, threatens the discretion given to trial courts, and blurs the distinction between our respective courts. Our role as appellate judges is critically important, but it often requires restraint. We are here to ensure that the law has been applied correctly and to correct harmful legal errors when we see them. It is not our job to second-guess trial judges or to substitute our judgment for theirs. We do not find the facts, but instead defer to the trial court's factual findings where there is any evidence to support them. We review the trial court's ruling on a motion to disqualify a prosecutor for abuse of discretion. Such an exercise of discretion is based on the trial court's findings of fact, which we must sustain if there is any evidence to support them. So there you go. Unless there's a sufficiency of evidence question, we've got to just go with what the facts were. Here, the trial court expressly found that appellants failed to show that the district attorney had an actual conflict of interest, failed to show that she received any material financial benefit as a result of her relationship with Nathan Wade. I do believe, I'll disagree here, because I do believe the wording was like, Oh, no, they did say immaterial. Okay, fair enough. Failed to show that she had a personal stake in the conviction of any defendant. Failed to show that her relationship with Wade involved any actual impropriety on her part. And failed to show that their relationship, including their financial arrangements, had any actual impact on the case. Because there was some evidence presented to the trial court that supported these findings, we are bound to accept them. The majority does not dispute these findings. Rather, it holds with the citation of no supporting authority, and apparently, for the first time in the history of our state, that the mere existence of an appearance of impropriety in and of itself is sufficient to reverse the trial court's refusal to disqualify the district attorney and her entire office. As shown below, the law does not support this outcome. Rather, it compels precisely the opposite. Where, as here, a prosecutor has an actual conflict of interest and the trial court, based on the evidence presented to it, rejects the allegations of actual impropriety, we have no authority to reverse the trial court's denial of a motion to disqualify. None. Now, when you get a one-word sentence in something like this, I don't think this person's playing lightly. They took the time to say, we have no authority, blah, 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 blah. None. Like, Judge Land is not playing. Even where there's an appearance of impropriety, our binding precedent and the doctrine of stare decisis require our restraint and do not permit us to impose a different remedy than the one chosen by the trial court, simply because we might see the matter differently and might have chosen to impose another remedy had we been the trial judge. And this is basically an argument of reasonable discretion, right? This dissenting opinion here, Judge Land is saying, you simply within the range of reasonable discretion. Judges have discretion, judicial discretion. If this is reasonable and you do something here, and another judge says, well, I would have done something here. Well, if it's all within the range, we don't have the authority to take issue with that. We could have personal issue with it, but as far as trying to reverse a decision, that's not okay. And there's no delineation or argument, really, by the majority in here of how Judge McAfee's decision to give this choice is an abuse of discretion and falls outside that discretion. That's the argument that this dissenting opinion is making here. And I get that it applies to a hot button specific topic, but I don't know. When it comes to trial courts and appeals courts, I feel like this is like the taboo type thing to try to poke at, right? I don't think appeals courts want to stomp on allowable judicial discretion, right? So we'll see if this goes, if they take it up to the Supreme Court of Georgia, if the Supreme Court of Georgia even wants to hear it. But it's not just a non-argument here in the dissenting opinion. I actually think it's a valid argument. For the last 43 years, for at least the last 43 years, our appellate courts have held that an appearance of impropriety without an actual conflict of interest or actual impropriety provides no basis for the reversal of a trial court's denial of a motion to disqualify. This is true in civil cases and criminal cases, and it applies to prosecutors. Our Supreme Court first addressed this issue in 1981, after a trial court disqualified an attorney based on an appearance of impropriety arising from the fact that counsel for a caveator, is that how you say that? Caveator, was married to an attorney who previously represented the propounder of a will. Concluding that counsel should not be disqualified under these circumstances, the Supreme Court declared that, although the issue has been squarely addressed in Georgia, courts in other jurisdictions have rarely been willing to disqualify an attorney based on an appearance of impropriety alone, where there is no danger that the actual trial of the case will be tainted. Accepting the trial court's finding that there was no actual impropriety, but rather just an appearance of such, the Supreme Court held that disqualification could not stand. Appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of impropriety. It is perhaps helpful to view the issue of attorney disqualification as a continuum. At one end of the scale, where disqualification is always justified and indeed mandated, even when balanced against a client's right to the attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidences. So this is where it's warranted. In these instances, it is clear that the disqualification is necessary for the protection of the client. Here we go. We're back to the middle. Somewhere in the middle of the continuum is the appearance of impropriety based on conduct on the part of the attorney. As discussed above, this generally has been found insufficient to outweigh the client's interest in counsel of choice. This is probably so because, absent danger to the client, the nebulous interest of the public at large in the propriety of the bar is not weighty enough to justify disqualification. Finally, at the opposite end of the continuum is the appearance of impropriety based not on conduct but on status alone. This is an insufficient ground for disqualification. This is particularly clear in this case in light of the trial court's specific finding that there was no actual impropriety on the part of any of the parties. And this is, let's see, the trial court in Blumenfield granted the motion to disqualify on the basis of Canon 9 of the then existing Code of Professional Responsibility, which provided a lawyer should avoid even the... So the importance of this footnote is, in this case, we're citing this case here, this argument. The ultimate result here was that somebody was disqualified, but it wasn't because of just a general discretion issue with the spectrum. There was, at the time, a Code of Professional Responsibility, which provided a lawyer should avoid even the appearance of professional impropriety. So the code was different at the time, and this gave the basis at that point in time. Notably, the Supreme Court revised Georgia Rules of Professional Conduct effective January 1st, 2001, and among other changes, removed Canon 9 and any mention of, quote, appearance of impropriety outside of the context of lawyers' direct dealings with the tribunal. So see current rule of professional conduct, 3.5, comment 2. Imposing an appearance standard on lawyers whose conduct could be seen as tampering with judicial impartiality. Compare Code of Conduct, Judicial Conduct, Rule 1.2, comment 2. Judges must avoid all impropriety and appearances of impropriety. So judges, and this dissenting opinion is emphasizing judges must, but not the lawyers, The fact that the rules have changed since Blumenfeld gives us even more reason to defer to the trial court's refusal to disqualify the district attorney here. See Herman v. Guttergaard. In one of Georgia's leading criminal cases dealing with the disqualification of prosecutors, Williams v. State from 1988, there is no discussion of disqualification based on mere appearances. Rather, the entire discussion is premised on actual conflicts of interest found not to exist here and actual disqualifying, quote, forensic misconduct, likewise found not to exist here. In Williams, our Supreme Court held as follows. There are generally two recognized grounds for disqualification of a prosecuting attorney. The first such ground is based on a conflict of interest, and the second ground has been described as forensic misconduct. A conflict of interest has been held to arise where the prosecutor previously has represented the defendant with respect to the offense charged, or has consulted with the defendant in a professional capacity with regard thereto. Such conflict also has been held to arise where the prosecutor has acquired a personal interest or stake in the defendant's conviction. And that footnote kept going. Hold on. Okay, this is a very long footnote. Holy moly, dissenting opinion. It kept going. So this footnote here talking about the change in the rules of professional conduct also said that the district court properly applied the conflict of interest standard and did not apply the outdated appearance of impropriety standard. So after this 2001 rule came into play, there's a 2006 case or decision at the 11th Circuit that said, hey, the 11th Circuit found that the district court did properly apply the conflict of interest standard, the new one, and did not apply the outdated one, which used to contain an appearance of impropriety standard that applied to attorneys. That's no longer there. It only applies to judges, the tribunal itself. So we have an affirmation from an 11th Circuit court here that this new rule definitely takes precedent over the old rule. So I think this is great for this dissenting person to include, like it or not. As a leading scholar on disqualification has noted in describing this movement away from an appearance of impropriety standard, prosecutors cannot realistically be expected to comply with the standards of impartiality required of judges. In many states, prosecutorial disqualification is deemed to be appropriate only when the remedy is needed to prevent the accused from suffering prejudice. And that's citing Richard Flam, Lawyer Disqualification. So a book with analysis. Hold on. Okay, so we just got finished quoting the Williams case here with this paragraph, and we're back to dissenting opinion. The nature and consequences of forensic misconduct in the prosecution of a criminal case. So another law review book. Here, there is no contention from 1954. Here, there is no contention that the district attorney previously represented or consulted with any of the defendants, and there has been no showing that she has a personal interest or stake in any conviction. These facts support the trial court's conclusion that she has no actual conflict of interest. In 2005, this court was faced with an appeal from a conviction where the defendant contended. Now, guys, in this dissenting opinion, like, look how much time we've spent on precedent, codes, decisions, affirmations by a Supreme Court of Georgia of a district court decision, right? This is the dissenting opinion that we've been looking at, and it's spelling out really the citations of authority. And I don't really think we got that in the majority decision. Is it enough? Will it go up to the Supreme Court of Georgia? I don't know. But in 2005, this court was faced with an appeal from a conviction where the defendant contended that a special prosecutor should have been disqualified. We explicitly rejected the argument that the appearance of impropriety alone is sufficient to require a reversal, and labeled the argument irrelevant to the case, given the fact that the defendant had failed to demonstrate an actual conflict of interest. And this is Whitworth v. State. We heard that cited a lot at the trial court level. Elaborating on this point, this court stated that no actual conflict of interest was shown. As previously noted, a prosecutor who is not a judicial officer is not held to as high of a standard of independence and neutrality as is a judge. The Supreme Court of Georgia has repeatedly held that an actual conflict of interest is required to warrant reversal for failure to disqualify. And is this a footnote? Okay, so we have a footnote. This court's opinion in Whitworth is physical precedent only because Judge Adams did not fully concur with all of the reasoning contained in the majority opinion. However, with respect to the issue discussed above, Judge Adams did fully concur with the two other judges. Writing separately, he stated that while he could not agree with all that was stated by the majority, he did agree with the result because there had been no adequate showing that the special prosecutor had an actual conflict of interest. On this point then, oh my god, we're going to go on another page again for another footnote, you guys. On this point then, it appears that all three judges were in agreement. Maybe we don't. Okay, I lied, we don't. Oh, thank goodness. These are very long footnotes, you guys. Now where was this footnote? Okay. In Camara v. Henson, disapproved on other grounds, Fulton County v. Ward Pogue, this court was presented with the issue under consideration here. Specifically, whether a trial court's denial of a motion to disqualify counsel based on an alleged appearance of impropriety should be overturned. Our holding could not have been clearer. We affirm the trial court's denial of Camara's motion to disqualify defense counsel because the trial court did not abuse its discretion in denying the motion in absence of an actual conflict of interest, or actual impropriety. Citing Blumenfeld, we elaborated. Absent an actual conflict of interest or actual impropriety, we cannot say that the trial court abused its discretion in denying Camara's motion to disqualify defense counsel. Mere appearance of impropriety is an insufficient grounds for disqualification. This supports the dissenting opinion. So, and I think that this is to me, this is an issue of, should this be the standard, right? I'm not saying that I don't think that there's a problem with this being the standard, but if that's somehow the standard that Georgia's decided to have and establish, yikes. And I don't think that this dissenter is doing all that bad of a job of laying out the pieces of the puzzle. So, it is what it is. Consequently, we affirm the trial court's judgment on this regard. In sum, we affirm the denial of Camara's motion to disqualify defense counsel because there is no actual conflict of interest or actual impropriety. And I always think it's interesting that, and I thought it was interesting during the disqualification hearings, the arguments there too. Like, to me, there's a difference when you're speaking about a prosecutor and defense counsel. I just think that for this purpose, there's an inherent distinction between a conflict of interest, maybe a defense attorney. Of course, there could be a conflict of interest with the defense attorney. But when it comes to a prosecutor, even if that prosecutor is not the DA themselves, that prosecutor might not be publicly elected, they're still part of the government. And I really think that there always should be a distinction for the standard there applied to somebody acting as an arm of the state in prosecution. And again, that would only be in the criminal realm. And I hate that it's kind of treated as one and the same. But in any case, in Georgia Trails and Rentals Incorporated versus Rogers, we once again affirmed a trial court's denial of a motion to disqualify counsel where there was no actual conflict of interest, stating, moreover, as the trial court found in denying the motion to disqualify, the appellants have presented no evidence of an actual conflict to support disqualification. The appellants repeatedly refer to potential conflicts in this circumstance, but our Supreme Court has held that absent an actual conflict of interest or actual impropriety, the trial court does not abuse its discretion in denying a motion to disqualify counsel. Finally, our Supreme Court reiterated these principles less than a year ago in a criminal case involving a motion to disqualify a prosecutor based on an alleged conflict of interest. In Levy State, the Supreme Court affirmed the denial of the motion to disqualify, succinctly declaring that the trial court did not abuse its discretion by failing to disqualify the assistant district attorney absent an actual conflict of interest. We've got a footnote. Oh my god, it's so long. Guys, at this point, I think Judge Land, who's penning this dissenting opinion, has given more of an argument just in footnotes alone than the majority wrote, right? If you go back to the majority opinion and you cut out all of where they're just reciting Judge McAfee's entire ruling, I think these footnotes from the dissenting opinion are longer arguments cumulatively than anything that the majority opinion put forth. Oh my god, these footnotes are killing me. Lee is notable because it involved a motion to disqualify a prosecutor. Thus, any suggestion that Blumenfeld and its progeny do not apply to prosecutors is dispelled completely by Lee. Further, all of these cases are consistent with the often repeated principle that disqualification of counsel is an extraordinary remedy that should be granted sparingly. That was Hodge v. Sexton, and we saw that, I'm pretty sure, like Kevin Armstrong, Adam Abadi, I think they talked about this in those hearings back in the spring. Hodge v. URFA Sexton, Bernocchi versus Ferrucci, oh my god, I'm going to butcher all these names, and Blumenfeld. This principle is just as true for prosecutors, including an elected district attorney, as it is for private attorneys, and there is no good reason not to apply it here. The elected district attorney is not merely any prosecuting attorney. She is a constitutional officer, and there's only one such officer in each judicial circuit. That's McLaughlin v. Payne. The district attorney, and see, like, guys, this is where what I was saying, like, a minute ago. Me, if somebody's a constitutional officer, there's only one of you, I think that's distinguishable and should have a higher, stricter standard. Unfortunately, what's being cited here, contrary to my wants and wishes, right? What I would think would make more sense in the interest of justice would be if somebody has a more important position, if you have more power, you should have more checks and balances on you. That's my stance. But here, what this dissenting opinion, this very long footnote is providing is authority suggests otherwise. In fact, it seems like there's greater protections offered to somebody holding this position. So that's something I fundamentally disagree with being the standard, but it seems to be the standard. Seems to be some authority here. And unfortunately, maybe in Georgia, I don't know Georgia cases like the back of my hand, but the majority opinion didn't really supply anything to the contrary to this. So, But the district attorney was elected by the voters of her circuit. We should tread lightly when asked to deprive the electorate of the attorney they choose to perform this job, especially where there has been no finding of an actual conflict of interest or actual impropriety. And then State v. And this is from 2024. I don't know if this is GC or GC. Disqualification of elected district attorney interferes with her performance of constitutionally mandated duty and cannot stand in the absence of an actual conflict of interest or legitimate due process concerns. If we are not going to follow binding precedent and have no good reason to overrule it, all of these virtues of stare decisis are threatened. In this case, the trial court expressly found that the district attorney had no conflict of interest and rejected the wait, hold on. That was a footnote. Let me reverse, guys. Scratch this sentence. I jumped ahead. Oh my god. This long footnote tripped me up, you guys. Oh my gosh. I kept reading after this footnote, but we didn't finish this, I don't think. Right? Where were we? Where was this footnote? This footnote was here, so we skipped a whole paragraph. My bad, you guys. Oh, god. Oh, this is a lot. Oh my god. This is crazy. The majority opinion in this case cannot be reconciled with any of these cases, but we are bound to follow them. Stare decisis is the preferred course because it promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. If we are not going to follow binding precedent and have no good reason to overrule it, all of these virtues of stare decisis are threatened. And I really do think there was a lack of delineation on the good reasoning to make the decision that the majority is making here. Again, these footnotes are longer than the argument put forth by the majority in this opinion here. These footnotes are killing me. You guys know I love footnotes. These are very long footnotes from this guy or lady. I don't know. I use guy synonymously. It applies to everybody in my world. But holy moly, I think this is true. Like the majority didn't really spell out, hey, this is vague. We're going to spell it out now. This is why we're spelling it out in the interest of justice, whatever the reason is. There's no authority. Well, but we need to make a decision here because XYZ. So in this case, the trial court expressly found that the district attorney had no conflict of interest and rejected the allegations of actual impropriety arising from her relationship with Nathan Wade. It rejected the notion that she received any material financial benefit from her hiring of Wade, that she hired him as part of a scheme to enrich herself, or that the financial arrangements had any impact on this case. It was certainly critical of her choices and chastised her for making them. And for what it's worth, you guys, I agree with this dissenting opinion's characterization of the way Judge McAfee penned his ruling. And in retrospect, we can't lose sight, but when that decision came down, you read the way Judge McAfee wrote that, and it was like, I didn't find this, I didn't find this, I didn't find this. There is an odor of mendacity, but, some of the stuff, it wasn't really shown, or it was immaterial. This is a correct characterization of Judge McAfee's ruling, whether or not you agree with the underlying sentiments and arguments and whatever presented by Judge McAfee. That is how he wrote that ruling. So, let's see. I take no issue with that criticism, and if the trial court had chosen in its discretion to disqualify her and that office, this would be a different case. And yeah, he's spelling it out if we go by McAfee's fact-finding. But that is not the remedy the trial court chose, and I believe our case law prohibits us from rejecting that remedy just because we don't like it, or just because we might have gone further had we been the trial judge. See State v. Evans. Decision to disqualify prosecutor based on an appearance of impropriety is within the discretion of the trial court, and the appellate courts will not interfere where, as here, the court's discretion was not abused. Right? So he's citing case law that's specifically saying that we're not supposed to interfere here, even though that case was overruled on a different ground. The ultimate determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. This is Bowers versus CSX Transportation Incorporated. Review under abusive discretion standard recognizes that there is a range of possible conclusions the trial judge may reach, and we will affirm a trial court's decision, even though we would have gone another way had it been our call. Do you think this dissenting opinion, it seems like they want to emphasize, I would have done something else too, but we just can't, our hands are tied. Like, he's citing all these cases here that say as much. United States v. Miller, abusive discretion standard applies to trial court's chosen remedy on motion to disqualify. Trial court has a wide discretion in framing its sanctions to be just and fair to all parties involved. Every day in courtrooms all over the state, trial judges solemnly and diligently fulfill their constitutional obligations and perform a vital and indispensable public service when they convene hearings, listen to testimony, observe witnesses, make credibility determinations, resolve conflicts in the evidence, weigh the evidence, and exercise their discretion in countless ways. We should not lightly interfere with their work or weaken their discretion by imposing our will because we don't like the result. Because I am convinced that this is what the majority has done in this case, I respectfully dissent. And that's the end of it here. And it seems like that dissenting opinion was 12 pages long. And this is a 31-page document, you guys. So very, very long dissenting opinion, especially when you consider like 4 or 5 pages of the majority. You've got your cover page, and then you've got like 4 or 5 pages that are just quoting McAfee's decision in the majority. So almost equally as long, the dissenting opinion for the majority. So, I don't know. My initial reaction on that, you guys, is like, I just fundamentally disagree with, don't like the notion that, you know, someone, whether they're elected or appointed, if they're in a position of power, I think there should be checks and balances. And I do think that I understand that part of checks and balances mean giving authority to do certain things and maybe constraining somebody's authority to do other things, right? That's checks and balance. You've got to have 2 there. But I don't know. Georgia, to me, reading this just seems like it's very much like, we don't want to touch anything. We don't want to ever step on the toes of a district attorney or constitutional officer. And this seemed to be a similar, I don't know. It's weird to see this dissenting opinion with all of this case law, and then to also know that the constitutional officer protections are something that Fani Willis, her office, tried to rely on with these open records request cases. And ultimately, Judge Rachel Krause was like, nope, not enough, right? But that's a trial court judge making that decision. And then it was affirmed, right? They didn't even want to, it seems like they didn't, I don't know if it was officially affirmed yet, but the appeals court didn't even want to take up an appeal on that decision. I don't know. I think that there needs to be some type of reform or delineation or something that maybe narrows the discretion that judges have when it comes to matters like this. But unfortunately, sometimes crappy statute, crappy precedent, crappy established authority. I don't know. Yes, so Mark, with the Court of Appeals decision here, they are saying Judge McAfee's option that he gave for Nathan Wade to just off-ramp himself wasn't enough to properly remedy the issue. So we're reversing that decision, and instead, Fani Willis and her office, Fulton County District Attorney's Office entirely, are disqualified from the Trump RICO prosecution. The court is not dismissing the indictment, but what it would do is it would go to, what do they call the board? Prosecuting, it was right at the beginning, somewhere. Oh my gosh, I don't know. Prosecuting Attorneys Council. And they should round robin reassign it somewhere else. And then again, wherever it's assigned to would have the decision they'll have prosecutorial discretion. We know that within Fani Willis's discretion, she chose to prosecute this case and continue to pursue prosecution. If it gets in front of a different prosecuting authority, they may or may not make the same decision to pursue prosecution, right? On top of that, there's an additional layer of, if Trump's about to take office, we got a 4-year pause on this anyway. So, yeah, thank you. Isabella was on it, the prosecuting counsel. Holy moly. I don't even want to look at words for the rest of the day after those footnotes, you guys. And I love footnotes. I'm not trying to throw shade on the footnotes, so they were just very, very long. They were very long. But holy moly. That was a lot of reading, you guys. I was like, I'm just going to share the document. This will be fine. But I was pretty surprised to see that the majority, their argument was just like reading Judge McAfee's and being like, oh, not enough, but didn't really spell out why. I would have liked to see it spelled out why. Why? Because in the future, if there's an issue like this in the future, all these quotes that we saw the dissenting opinion cite, the majority here could have given us something that could have been quoted, parsed out, pulled out, and used again as a constraint on somebody that, in my opinion, has a lot of power. It's a position of power. There could have been something in the majority opinion spelled out that could have been used as a constraint in the future. And I personally, my stance is when it comes to prosecuting positions, I would like to see more restraint than freedom to do whatever you please, right? And that doesn't apply just, my stance is not isolated to Fani Willis. It's not isolated to Fulton County. I think we should always hold in high regard any restrictions on the government's power to prosecute the people, right? Give them the power. It's necessary for justice, right? Victims need advocates, but I don't think prosecutors should have free reign to do whatever they want unchecked, right? And to me, a significant enough appearance of impropriety, maybe that should be enough, and maybe it's not delineated enough by what currently exists in the case law. But I think the dissenting opinion, because I don't have anything to compare it to from the majority here, I think the dissenting opinion spelled a lot out that supports the argument that, hey, I'd like to do something different too, you guys, but it just isn't here. And that points to a problem in the existing authority. So there was an opportunity here for the majority to create some new kind of precedent, and they just didn't take it. Which I don't know if that's intentional, right? Maybe they don't want to constrain this. Maybe they didn't really want to take a stance. They wanted to do something here in this decision only, but didn't want to make it precedent. I don't know. So yeah. But yeah, I don't know. Fulton County in any case still seems crazy, regardless of my my micro analysis here of the two sides of the opinion here. I still think Fulton County is overall a hot mess. Everything that's going on. And again, these are all this talk about public interest, right? Fulton County has been in the spotlight for so many reasons. Obviously, YSL RICO trial is one of them. Just a whole mess. More recently, not directly tied to the district attorney's office, but the district attorney's office is what helps fill the beds at the Fulton County Rice Street facility and any other annexes. We have all this buzz about the state of the prison system, the jail system in Fulton County. We've got now a lawsuit with Shannon Stillwell Jackson as a co-plaintiff, right? And any unnamed parties that might join on board. It's a class action suit. It's looking to become a class action suit. Like, all of this in the news. Not good for Fulton County. Just a hot mess. Am I wearing one of Thug's? No, not even close. I think I'm like 4 decimal places off of maybe 5 or 6 from anything that Jeffrey Williams would be wearing as a watch. So, yes, this is a Picasso shirt. Oh, is it like reversed on your screen? Like, does it read like a mirror image? But yes, it is. Also, shout out to, again, thank you to Classy Beats. We are going to be redirecting over there. Classy Beats is going to be talking more about the warrant issues with Diamante Kendrick. There's also Pee Wee Roscoe, Jimmy Winfrey, supposed to be released, but has a probation issue popping up in the state of Florida. I'll pull that up real quick. Classy Beats is going to do a deeper dive into that. We're going to get over there. But as a quick rundown, let's see what we've got. Here we go. Okay. So it appears, although that Jimmy Winfrey was released from Fulton County Jail earlier this week after taking a plea deal earlier this month, he's been booked in Florida on a probation violation. So, like, my whole reaction is just, what else is new? Like, this is going to be the MO, right? Somebody gets released and they have a different probation violation issue. And I don't know the specifics of this, but the stuff going on with Diamante Kendrick's probation revocation, the timing of it, it does seem a bit retaliatory. And Classy Beats is going to do a deeper dive into that. Also, guys, I had a great time yesterday on WTF Wednesdays with attorney Kayla Bumpus Jackson, Millionaire Mel, and Miss Jefferson, and a whole panel of guests, including Doug Weinstein, Ashley Merchant, just a whole guest star lineup. So make sure you check that out as well. I'll get the link for you in a second. But Kayla talked about it there as well. And what better source than the person who was actually representing Diamante Kendrick in the matter? Let's see. WTF Wednesdays, holiday party. Oh, and yeah, Shannon pops on the panel as well. I'm like listing off all the guest appearances. I certainly didn't come close to listing all of them. It was, shout out to them for managing that stream. There were a lot of guests, more than 10 at a time, were trying to get into the waiting room. And Kayla had to like kick people out to allow people to even get into the backstage of her StreamYard. So here is the WTF Christmas party. Link in the chat if you want to check that out on a replay. That was a great time. Yeah, so Shannon was on the stream, and the first comment says at 21 minutes in. So if you go 21 minutes into the stream, I mean, I could just share the screen. You guys can go watch it on your own, but... Oh, 21. Let me share my screen. He makes an appearance up here. He makes an appearance for a little bit. And Melnick was here. Also, shout out to Alley Cat. Big fan of Alley Cat. Love her on Twitter. Super nice. Great insights. Big supporter of, making sure no issue in this trial goes unchecked, right? If there's some BS happening with this case or Fulton County in general, call it out. Love Alley Cat. Was really happy to see her pop up on the panel as well. But yeah, go check that out. I'm not going to like replay the stream here. But yeah, that's about 21 minutes in, and shout out here. It was Bad Boss that made this comment with the timestamp, so shout out to them. Yeah, Jamie. So I like it. It seems messy to me. It seems messy. Oh my god, I forgot about the best part, you guys. Hiring right under, guys. All right, and I'm only gonna show it here because Dennis posted it on X anyway. Now, Miss Sylvia is going to be in the bottom left screen. This is her ugly sweater. Let me make this full screen.
Oh, Miss Sylvia, everybody's looking.
Wait. This is her ugly sweater. It's a picture of Dennis. She just clipped a picture of Dennis to her sweater, you guys. Look at Miss Jefferson like losing it over here. I thought it was really wonderful that Kayla brought Miss Sylvia and Dennis together on the stream. The three of them, the panelists, coordinated this in advance. So I was looking forward to this. I knew it was coming, but didn't spill the beans. Kayla called me. She's like, guess what I'm going to do? She's like, I'm getting Miss Sylvia and Dennis on our Christmas party stream, and we're going to make them watch their Rule 22 hearing together. So when they got called up, made them watch it all. So definitely a great stream of memories. Like, you can see it's 3 hours long. The panel's changing. Tons of faces pop in and out. So definitely check that out. There's no way I can summarize it for you guys in 2 seconds. It was a really good time. It felt like a family gathering, right? You know, you get your family gatherings for the holidays. There may have been some heated moments between some people in the family throughout the year, but you come together for Christmas. You bring it together. So, let's see. Yeah, those lovebirds. It was the whole time. Oh, and Martinez Arnold down here. Duke is on. I'm telling you guys, there were just so many guests. Also, shout out to Mimi for becoming a new member. I think you've been a member before, so I'm going to say thanks for becoming a member again, supporting the channel. I've got the ADA Sprinkle song. I'm going to make that public, but it was members only as a sneak peek for a few days. We're also going to be naming the channel Hedgehog. Members got a head start on picking names, so more on that on a future stream. Kimberly Brown, good morning. Thanks for being a member for 3 months. Tay Biz says, this is great pre-L for the state. More L's to come. What up though, Kat and Chit at? I like that. I lost my uncle on Monday early evening this week. Oh no. Very sudden loss and this really stings, but I'm in good spirits today. I'm glad you're in good spirits, guys. And, you know, when you deal with loss, don't ever feel weird or like apologize if things just hit you out of nowhere, right? I think everybody can understand. You know, Tay-Biz, you're in good spirits. You're so positive and supportive. You're funny. You're the person that makes people laugh. But nobody would think any less of you if something just strikes in the moment and you get upset all of a sudden. And sometimes that's the way it goes, right? If you're in good spirits now and you get down a little later, it happens. I'm glad to hear you're in good spirits, though. I'm sorry about your loss, especially around the holidays. The whole chat is here for you, Tay-Biz. And I would love, you know, always feel free, reach out to me if anything, of course. You know, it's been a sad week, and I think the holiday seasons are tough. Losing someone around the holidays, or even if you lost somebody earlier in the year or years past, you get the holiday season together, and then that person's missing from the table, right? It's always, holidays are always kind of bittersweet in that way. So, Tay-Biz, you bring so much like laughter, positivity, cheer to people. I hope we can bring it back to you. And I hope you're still in the chat right now. I'm getting to you late, but I'm going to message you regardless. But even if he's not here, guys, show Tay-Biz some love in the chat. Definitely big love for Tay-Biz over here. I see it going already. Thanks, Bridgetta. And I don't know, you know, not being sure of if things are going to strike any moment. I don't know if you plan to go live anytime soon, Tay-Biz, but I cannot wait for your next live video. I will be in the chat, making sure that we're laughing right back with you. Guys, here is Tay-Biz's channel. Make sure you go over. What a nice way to show support. He's almost at 2,000 subs, which is very, very awesome. What a great Christmas gift if we can get him to 2K. But Tay-Biz, we are here for you. So much love for you, and I hope you keep creating. Keep on keeping on. Miss Love's disappointed father. See, this is the thing, right? You get down, you have a sad topic, and then 2 seconds later, something hilarious pops up. And Matt Rose, the username here, Miss Love's disappointed father, never fails. Matt says, thanks for being so great at what you do. Well, thank you for the kind words and the compliment. Thanks for the laugh. Steen, and I don't know if it's Stein or Steen, like short for Christine, so I'm going to say Steen. New member, welcome back. Ryan also turning green today. And hold on, we have an appearance by Pantene Profi. My Pantene queen was right all along. Referring to Ashley Merchant, that was the nickname. I believe that started in a lead and AV collaborative stream. And speaking of, AV is live talking about this disqualification motion. So, if you guys got here late or want to go through it twice because it was a mouthful, or you want to hear a different perspective or hang out in another chat, I cannot redirect to AV, and I'm going to be redirecting to Classy Beats anyway. So, for two reasons there. AV's link, dropping that in the chat now if you want to go check that out. But yeah, the Pantene queen, anytime she would pop up on the screen, the chat, TLA's chat would be like, Pantene, Pantene. And then one day, this bottle, I think it was the same day it started, the Pantene Pro V popped up as an account. It just popped up on the screen, was in the chat. And it's one of my favorite things about YouTube is when people like Pantene Pro V, whoever you are out there, just take the jokes, the humor, the fun moments to another level. So I appreciate the super chat. Good to see you over here. You've brought me a lot of laughs throughout the years, months, especially over in other chats. So thank you so much. Black Butterfly says, I love when Lead says Miss Sylvia and Mr. Dennis are the best frenemies on YouTube. Yep. And I mean, for what it's worth, I mean, I don't really handle drama that well. I just like stay away from it. But they, to me, both of them have a skill where they can embrace it and it works for them. Right? So it's different for me. It's not something I could do. I'd probably just cry. I'd probably just cry if someone online had an issue with me. I'm pretty soft-skinned with certain things. I'm thick-skinned for other people, on other people's behalfs. But for me, I'm just like, oh no, I'm sorry. And it really gets to me. So they have a skill, a personality trait that I lack, where they can ride over those bumps. And I don't have a story with Sylvia at all. But with Dennis, I did get into him like 5 days ago, 6 days ago, arguing with him about him copyright striking Cuff Boys and Cam. And he pushed back and eventually was like, all right. And, you know, it's all squashed, but not afraid to butt heads with people and still get up on a panel and celebrate the holidays with them. I think that's a good thing to see. And I really like that Kayla, Mel, and Miss Jefferson took that approach and put that together and coordinated it in that way. So, let's see. STS says, sis admin, yeah, you gotta change your picture. So STS is still letting the cone of shame live on. Guys, sis admin Simon got the cone of shame taken off. But we still have the relic of the past here with the profile picture. And STS says, as long as he behaves himself and doesn't paw his ears. Look, one thing about cats, no matter what cat it is, they want to do something, they're gonna do it. So Simon has that determination to get behind those ears. You might need to bring the cone back out. But yeah, so maybe a little premature to change your profile picture, I guess. But in due time, in due time. And let's see, I see Cuff Boys is the homie. Yeah, shout out to Cuff Boys. I mean, Cuff Boys makes this trial, you know, I'm not on TikTok that much, but I understand that there's a bunch of creators that do TikTok content about the YSL trial. But over here on YouTube, you have I'm Not a Lawyer But, you have Cuff Boys, you have Thugger Daily on X. You know, these shorter recaps. Without these shorter recaps, there are thousands of people that would not have been able to catch up and get interested and understand what was going on in the first 100 days or so of trial that they missed, and be able to jump in and become what I think was an extremely powerful force. I really think the public interest in this trial, mostly after the almost arrest of Brian Steele, it wouldn't have been accessible without creators like Cuff Boys that took that condensed recap style format seriously and did it consistently. So I think his style of content is really important. And we're talking about, this was a copyright strike. Dennis did a copyright strike to Cuff Boys, and Cuff Boys tried to resolve it behind closed doors, and Dennis Byron wanted like $2,500, saying, you know, it's his copywritten work. But in my opinion, I'm not an attorney, but there is something called fair use. And when you have a 3-hour interview and you shorten it down, I think it was like 12 minutes and 50 seconds or something like that, for Cuff Boys' reaction to and recap of the juror 409 speaking. You know, it did use clips from Dennis Byron's channel, but to me it was newsworthy, and Cuff Boys was transforming it, reacting to it. It wasn't a copywritten work in its entirety, right? If Cuff Boys had reacted to all 3 hours of the stream, maybe that would be a little different. You know, fair use gives certain exceptions where you don't need permission to use somebody's work. And I would argue that it was transformative enough. I'm not a lawyer, I'm not a court. I am not a copyright court, so my opinion really makes no difference. But on YouTube, you have the option to, if you have a content ID match, or you notice somebody's using your content, you can claim their content. And you have the option to write to somebody. You can say, hey, just sending a communication. You can take partial monetization. And it's a big chunk, guys. So if you have a 3-hour stream and there's like a little clip that matches somebody else, your monetization pretty much goes to that person, even if it's just for like 11 seconds. A good percentage of your ad revenue for that video goes to that person. Then there's a very extreme measure you can take, and that's to strike a channel. And that's really bad. If a channel gets 3 strikes, their channel can be gone from YouTube. So I'm not saying I think people should be able to just go around and re-upload other people's work willy-nilly and whatever the case may be, but I do think, you know, fair use is a thing for a reason. And YouTube, when you do these measures like copyright striking somebody, YouTube isn't a court. YouTube will just allow people to make the strike and let you guys handle it on your own. But YouTube will take the content down and leave a strike on your channel, and if you get 3, you're out. There's been some bigger issues. I don't know any examples offhand, but I've seen them. Every once in a while, you hear of somebody getting copyright stricken as some type of like retaliatory move, and it takes months to get resolved because YouTube will allow it, being overly cautious, even if somebody's just being slick. And you know, there's been instances where somebody's uploaded content that's somebody else's and then struck the person whose content it actually was, right? So Dennis did all that, and it was like, it felt like a whole night of just arguing. And then finally he's like, all right, I'm going to remove the strike. So for what it's worth, it ultimately ended with the correct resolution. So, but at the same time, you know, I personally don't mind if people, I like to share information. So I feel like if someone's sharing my content, you know, really they're probably just like sharing a document or whatever, which is not mine. I'm not trying to own documents. But I'm not trying to, I wouldn't want to own anybody's opinion or reaction to things either. I think the YouTube space is really important. And as long as somebody's not just blatantly reusing somebody else's work, I think fair use is important to remember. So, let's see. Yes, I see this here. I think I'm missing half the conversation because I'm blathering on, but that is so awesome. I love that everyone's trying to get the play button for Jeff. So Jeff Legal Vices, who passed away at the beginning of this week, another great streamer, made everybody laugh. One of those people that just brought everybody joy and made them feel included. No matter whether you're in the chat or on the panel or just in a message, he's checking in on you. Passed away, and yesterday he was at 85K at the beginning of the week, subscribers, and he got to 100K. So I think they're sorting out the logistics, right? Figuring out how to make sure they get that play button request, but it seems like he will, if all goes well with YouTube, get that play button placard that you get when you hit 100K subscribers, which is just so awesome. So awesome. And again, you might not know Legal Vices if you don't know Legal Vices. He had a thing going where he didn't tell his family he was a YouTuber. He didn't tell his family he had this YouTube channel and had like 80,000 subscribers. He was waiting to see if when it passed the line, his family would find out on their own and be like, oh my God, I just saw you on YouTube. What the heck? They didn't find out, and they've just discovered like what's really a treasure trove of memories where they can go and watch him for hours being hilarious, being well loved, really insightful, and then get this like memorial posthumous YouTube play button. Really, really awesome stuff. I think a lot of people have done tributes to Legal Vices. I think if you type Legal Vices, like tribute or memory, you can come up with a lot of those memorial streams. Aussie Overlord did a really cathartic one, like the night everything happened. But I can't list all of them, so I'm going to link to Legal Vices channel in the chat if you want to go and revisit some of his content. you know, Sarah Boone trial, YNW Melly, like all of these different cases, tons of cases if you want to go back and watch any. But if you want to watch some of the memories and some of the impact that he's had, seriously, type like Legal Vices tribute and you'll get a bunch of panels from Donnie on Direct. Megan Fox, a reporter, not the actress, did one as well. She did a call-in show where his son called in. Lots of content out there. Like everyone, I think, like Potentially Criminal, like so many, there's so many streams, guys. There's just so many, I couldn't list them all. But really, really sad to hear that news. STS says at least 5 tribute videos have been in my stream. Yeah, I mean, really, really well-known, well-loved, well-respected. Yeah, Chloe, 1,000,000%. Chloe Alberts Revenge says he was the best. If you're a regular on his channel, he truly did become your friend. He spoke to people. Yep. 1,000,000,000%. Let's see. On a kind note, Bridgetta says, Kattnotwilliams, thanks for all you do. Thanks for the kind words. I just get up on a screen and talk sometimes. Chloe Alberts Revenge says, let's see, Cat in the Hat, watch Megan Fox's YouTube Wake for Vice. Is this the call-in show? Okay, sorry. I said it on my own, but yeah. Let's see. Megan Fox. And it's crazy because I have to like type context to find the right Megan Fox's channel, even though I'm subscribed. Like, YouTube's so pesky. Okay, so this is the call-in show. All right, so the link I'm dropping now is if you want to get, I believe it was probably about 20, 25 minutes in where his son Connor calls in. And especially if you guys watch Legal Vices, I encourage you to watch this call-in show, at least the part where Connor calls in. It's incredible how similar, just from hearing the way Connor speaks over the phone, you can see like father-son going on, which is really awesome. So there's Megan's link in the chat. Again, in all seriousness, if you search Legal Vices, Jeff Legal Vices, you'll get a ton of these tribute videos. All really incredible to see and really cathartic if you've recently lost a loved one. I felt like it was good for me. You know, after losing my dad like 2 years ago, I never really dealt with it, but seeing people react to this, hearing it kind of gave me some of my own like bit of release. So yeah, this was crazy news too. CLR Bruce Rivers' son passing away. Yeah, this was crazy. So I'm well aware of who Bruce Rivers is. I know he's been well followed for a long time. To be honest, for whatever reason, it's like I would only see his content every once in a while. But throughout the years, like speckled tons of his content, and his son is and was an integral part of not just being behind the scenes and making sure the tech is working, but you know, he had his own little camera view. He had his own insights and perspectives. You heard their relationship play out on camera, and you know, so you have a creator losing their son who was an integral part of the show that the audience knew really well. And again, around the holidays, nothing easy about that. Yeah. Yeah, so Florida lawyer, that's how I felt too, like what? Hearing that. And I don't think I heard until, was it Uncivil Law? I think Uncivil Law did a video about Legal Vices and Michael at the same time, and that's where I heard. So just a few days ago. So like crazy. Yeah, and I don't know the details either. But yeah, that's rough. And then like, I mean, guys, I just hit like the play button and, you know, at some point maybe put a team together and coordinate this or something. Okay, wait, no, actually, even if we lost a mod, I'm not, God forbid, in the words of Brian Steele, hitting the go live button would be a different experience each and every time, knowing that somebody was now absent from the experience when we would ordinarily go live and expect a person to be present. right? Hitting the go live button would be different every single time from something like that. But can you imagine like your son, your family member, a partner in the creative process? Like I can't imagine how you don't think of that every time you hit go live. So that's got to be a lot to deal with. So, with that being said, I do see Finding Good. We're talking about that warrant. I am way late from getting you guys over to Classy Beats to get a deep dive on these warrants, more on what's going on with Christian Eppinger. It might be on replay already. Okay, so we're going to do a link. I'm late. Make sure you leave a comment that says replay crew for Classy Beats. So there you go. There's the link to that there. My bad on holding you guys up there. But yeah, I hope everybody's having a good holiday. I know not everybody like celebrates the holidays. Some people celebrate holidays but do so lightly. Some take it very seriously. Whatever you do, you know, this time of year, I feel like no matter what it is you do or don't do, it's a time that makes you think of families, makes you think of memories. So I hope everybody's doing well. Can be easy, can be hard. My best advice is if you have something from your childhood, right, that if you celebrated holidays as a kid, find a way to bring that spirit to the surface. One of the very selfish reasons I want to do the Angel Tree Project is no matter what was going on, you know, as kids, I think my parents tried to shelter me and my brother from anything that could stress us out. Whatever they might have been going on financially, dad losing a job or something like that. They always tried to make sure we had a big Christmas tree with presents wrapped up underneath it. And I remember that feeling every single year, even though I'm in my 30s and we're like, stop getting me stuff. We have enough stuff, right? Totally different holiday experience now, but that memory's still there for me. So a very selfish reason why I like to do the Angel Tree projects is it makes me, even though I'm the one giving the gifts, it makes me feel that same feeling I had when I was a kid and got to see the tree. So whatever it is that makes you feel like the holiday spirit, could be cookies, could be eggnog, could be taking the day off work and doing nothing for a day. Like whatever it is, I want everybody to have their holiday feeling, whatever that is. I think everybody deserves that at least once a year, and what better time than the Christmas season. So, oh, so the internet's saying a motorcycle accident. So I'm not sure, but that's rough. That is rough. So, destined to be, I'm trying to work out a mailing service that I think it's like a facility. Instead of a P.O. box, I think I'm doing this other thing where it's just like they store it and they like go back and get it from storage for you. It's like kind of like a P.O. box, except you got to go to the desk as a service. I just kind of want to make sure it's like accessible, because a P.O. box, like the ones at the post service near me are like pretty expensive, and it doesn't even look like, I know somebody once said they wanted to send like a hat, and the first two sizes available, I don't even know if a box with a hat in it could fit in it. So I have an alternative that I'm looking at. I've just got to vet it and commit to it, or just get a P.O. box. So it's coming. Sorry I'm like slow on that. I'm slow on stuff like that. It's just me. It's who I am. So, but with that being said, yeah, like a virtual address. That's what it is. That allows like package delivery and pickup, rather than, there are some virtual addresses that I've used for companies where they just scan letters and show me the contents, which is fine if you're only getting paper mail. It doesn't really work for packages that you want to have in person. So Brooklyn, the wish list, I believe I'll double check. That was for the Friends of Children of Brevard, but I think they shortened their wish list because they put everything together on December 9th. So we got everything shipped there before the 9th, and everybody else too, right? It wasn't just this stream. People sent stuff independently. I think I pulled it up and right now they just have like the ongoing, you can donate a gift card. And the reason for that is because there's a logistics of, they have to get this stuff from Amazon, then they have to get it to the foster care parents, and then they have to get it to the kids. So I think They do have a gift card wish list, but it's not the same. But there's a link, and looking at it, like popping it up, it looks like it's just like 4 different gift card types. But next year, if you missed it and want to do the gifting, we will definitely do it next year, of course. Even if I stop streaming, you guys, I'm going to go live next Christmas, and we're going to do this around November, right? We do it early because I need the time to process all this. We'll do some shopping again in November. I already have it on my calendar, just so you guys know. A kattnotwilliams wish list. Maybe. I don't know about that, but maybe. I'll tell you maybe. With that being said, I'm sorry again that we're late on the Classy Beats thing. Go and tell him that your replay crew. Let's get the link one more time. So feel free to click that and go over there now. And I don't know, do we have... I can't redirect to AV, but let's see if anybody else is currently live that I can redirect to. Here's the link to AV, since I can't, again, redirect. Who can I redirect to? We'll go on a trip, you guys. Taylor Umbridge is doing YNW rewatch. So we can do that. And again, that's going to be YNW Melly. And, you know, he's awaiting retrial. So this is a rewatch of the first trial. So that's where this will redirect to. But you can also, I just shared the link to AV is currently live. And I also shared the link to Classy Beats replay. Please tell him replay crew. Sorry, we're late. But yeah, we'll go over to Taylor Umbridge, who's live right now, talking about a case that a lot of people have been interested in or are trying to get into. So a rewatch is probably a good thing to do. And great message here from that guy, Nick. Oh, hey, Merry Christmas, y'all, or whatever holiday you celebrate. The sentiment is the same. Yep, good vibes all around. Sapphire Ridge News in the chat. I see Bay here in the chat. Good to see you. And Chloe, you know, we've got to connect somewhere. Again, Chloe was one of the first people I thought of when I heard the news about legal vices. I thought of Chloe. I thought of Flux. Again, it's just a testament to, you know, I only had a few personal conversations with legal vices, and hugely supportive, hugely welcoming of, hey, who's this new person in the YouTube space that used to be in my chat? Like, that's kind of how he approached me. And I love him for that. But really, like, for me to know and be able to think off the top of my head, so many people that I knew would be affected by his passing is just a testament to how many people and how many lives he's touched. Again, 80,000 subscribers, it's a lot more than just a number. He really made sure to make people feel included, have a place to go almost every day. And without legal vices, I wouldn't know Chloe Albert's Revenge. So, sending love to everybody here. We're going to wrap this up because I'm losing my voice. I've been losing my voice all week. And that reading, those footnotes were getting me. We'll do some YNW Melly trial, and, you know, I don't know if you'll see me before Christmas. So, if that's the case, I hope everybody has a good one. All right? See you guys out here in the YouTube streets. Have a great holiday or whatever it is you do. Everybody, please take care. Bye-bye.